Everybody, and welcome to this edition of Western Michigan University Cooley Law School's Community Conversations series. I'm Paul Zielinski, and I'll be the facilitator for today. Also joining us is President and Dean James McGrath, who would like to make some opening comments. President McGrath?
I just wanted to say thank you to everybody for coming. I think, Cooley is well known for a number of things, especially the work of Joe Kimble and Mark Cooney in plain legal language. Very important subject, and I'm excited that you're all here. I'm excited to hear it because I think they're both great speakers and great teachers. So welcome, and thank you so much for coming.
Thank you, President McGrath. Today's topic is plain English writing in the legal profession, and it can't get any better than this. With us today are two esteemed colleagues most of you know, and arguably the founder and surely the national leader in the plain English movement, distinguished Professor Emeritus Joe Kimble. And joining Professor Kimble, and may I call you a protege, is Professor Mark Cooney. The bios of these two impressive people we posted in the chat. I think they may already be there. And each of these guests have written extensively about using plain English in legal writing. In 2010, Professor Kimble won a Lifetime Achievement Award from the section on legal writing, reasoning, and research of the Association of American Law Schools. In 2015, he received the John W. Reed Lawyer Legacy Award from the State Bar of Michigan. And in 2017, Scribes created the Joseph Kimble Distinguished Service Award. Professor Cooney is the editor of the Scribes Journal of Legal Writing, having previously served as its associate editor. He has chaired the State Bar of Michigan's appellate practice section and has served as a plain language consultant on the State Bar Standing Committee on Standard Criminal Jury Instructions. That's a long title. He is also a founding member of the Michigan Supreme Court Historical Society's Advocates Guild. Now, I want to remind everybody, and those of you who have been here before, this is a conversation, and we encourage you to ask questions as our guests are making their comments. We will be recording this section of the series of this program, and if you are not speaking, we ask that you mute your audio. So let's get the conversation started. Each of our guest professors, Kimble and Cooney, would like to start today's conversation with some opening comments, and we'll start, of course, with Professor Kimble, if you would like to take it away.
Thanks, Paul, and thanks everybody. Can you hear me okay?
Yes, we can hear you very well.
Good. Okay. Well, thanks for being here. This is a great pleasure to be able to talk about my favorite subject, or one of my favorite subjects, plain language. Oh, Terry, you're taking photos. I wonder what you were doing. All right. Well, first of all, what are we talking about when we talk about plain language? We're talking about basically about clarity in public communication. This is not about literature. We're not trying to simplify Shakespeare. See, this is about public information, consumer information, and it touches everything. It touches just about everything. Mark, I think, is going to sort of handle the legal side of this, but on the broader consumer side, we're talking about health information. We're talking about insurance information. We're talking about bills of all kind, notices, flyers from business and government, government forms of all kind, and we're talking about, for crying out loud, we're talking about voting. We're talking about clarity in voting and people being able to vote and record their vote the way they intended it, right? So now I am going to show you some examples. They're from a Washington Post article. There's your ballot instructions. I read the English part, and then I go over here and vote for the governor. And then I go over here and vote for the 4th District Court of Appeals. And look what I would have missed. The part on voting for senators is tucked in at the bottom. And of course, it wasn't circled with red. It was circled in red at the article just to illustrate it. See? And lots of people didn't vote for senator. This stuff is everywhere. How about the New York ballot? There's a beauty. What do you think of that ballot?
It's confusing.
They can't change it for various legal reasons, apparently. A lot of people in Minnesota didn't sign their ballot envelope. So look what they did the next time around. They highlighted it so people wouldn't miss signing it. Right? There's a group called the Center for Civic Design that is doing some wonderful work in this area. And now, the granddaddy or the grandmother of them all. Watch this. Recognize this? You have to be a little older to recognize this, but this is Palm Beach County, Florida, November of 2000. It was an election that was decided by just over 500 votes because Florida, Florida held the difference. I mean, whichever way Florida went, the country went. And 3,000 people, or I believe it was around 3,000 people, voted for Pat Buchanan. And even he, I believe, said that not that many people intended to vote for him. And why did they vote for him? Because look, if you go number one, over on the left-hand side, George Bush, number two, Al Gore, Bush number one, Gore number two. Okay, Gore's the second one down. I'm going to punch this hole. I'm going to punch the second hole down. But of course, that was a vote for Pat Buchanan. Right now, you can say, well, they should have seen the arrows. They should have seen the arrows. But that's not the point. The point is that the ballot should have been fail-safe, or as nearly fail-safe as they could have made it. Right? You know what? If they early on had brought 10 people in and had them try to use this mock ballot or sample ballot, they would have discovered the problem. But they didn't test it. And that election, of course, that ballot right there changed history. And it changed the U.S. Supreme Court. I think Mark is going to cover the legal side of this.
Sure.
And so I will leave out the legal side, although the voting is sort of legal side. But I mean, this kind of stuff drives people crazy, and it has consequences. Right? Now, there's this really pretty good little book called Writing. I don't know if you can see it because I know the virtual background. Called Writing for Dollars, Writing to Please: The Case for Plain Language in Business and Government and Law. And it's full of data, studies to make the case, as I say, case for plain language in business, government, and law. And I'll read you just a few pieces. Siegel and Gale, which is the big branding company, did a simplicity survey. And they found out that 50% of people find their insurance, credit card, and cell phone contracts extremely difficult or somewhat difficult to understand. From 32% to 52% sometimes or never read those materials. And a stunning 84% are more likely to trust a company that uses jargon-free language in its communication. This is the thing. I mean, it's not just a matter of frustrating people and driving people crazy. It's a matter of building trust. I mean, I say at the end of the book that the plain language could even help to restore faith in public institutions, assuming that those institutions may be a big assumption, but assuming that those institutions are trying to convey accurate, true information, assuming that they're trying to convey accurate information. But of course, there's some issues there. Okay, so that's the consumer side of it. And just, think of the pleasure that comes from getting a form or a document or something you're supposed to read and act on, and it's clear. And think of the frustration and the irritation that comes from not being able to understand it. It's driving everybody crazy. That's just the consumer side. I haven't mentioned the business side. Now, of course, they go together. They go together because, of course, trouble for the consumer usually means some kind of trouble for the business. Poor communication costs business and government untold millions and billions of dollars every year. And I've said that poor communication is the great hidden cost of doing business and carrying on the government. In this same little book, Writing for Dollars, Writing to Please, I summarized 50 case studies with all kinds of numbers, data to make the case, to make the business case for plain language. Now, again, these numbers can be a little bit mind-numbing, but just to give you a couple of examples. The Veterans Administration revised a form letter, and then they tested it at one regional office. They tested, how many calls they were getting because people didn't understand this letter before and after. Before, they were getting about 1,100 calls a month, and after they revised it, they were getting they started getting about 200 calls a month. The Arizona Department of Revenue rewrote a letter to business taxpayers, and the response rate, after they revised it, the response rate jumped from 15% to 85%. Washington Department of Labor rewrote a letter that tripled the number of businesses that were paying a commonly overlooked use tax. Next year, revenues jumped by $800,000. A study involving payday loans. Half of the participants, half of the borrowers got their payday loan in a plain envelope. The other half got their payday loan with this little graphic on it. It showed exactly how much this was costing them, these expensive payday loans. And the next round of borrowing, the people who got the envelope with graphics on it borrowed 17% less. This doesn't sound like a lot of money. They borrowed 17% less. But across the board, across all, taking all payday loans into account, that 17% decline would represent an $8.5 billion decrease, $8.5 billion decrease in the amount of money that people borrowed in payday loans. So, and it's not, by the way, these are all United States examples. This is happening all over the world. It's not just in the United States. The book includes examples from Canada and the UK, Scandinavian countries, which in many ways are leading the charge on this. I think, Terry, you've got a link in the chat to some studies that have been done in Norway. I mean, these are incredible numbers that are saved, let alone consumer frustration, from just writing documents in plain language. So in the end, what is plain language? The three leading international plain language organizations, Clarity, got to stop screen sharing. The three leading international plain language organizations have defined plain language as like this. A communication is in plain language if the reader can easily understand, find the information they need, understand it, and use it. Find, understand, and use. See? And again, this is very much an international movement. We just held a big 3-day international virtual conference, and in the end, what do people do when they can't understand the information that's provided to them? Of course, they call the call center. They proceed incorrectly. They fill out the form wrong, or they do nothing, which is worst of all. So, this is a big deal. It's a huge deal. And if the voting examples don't convince you, I don't know what will. So with that, I'm done. Thank you very much.
Thanks, Professor Kimble, and I'm sure there will be some questions following up. But let's turn to Professor Cooney, who we'll continue with some questions and we'll get into the conversation.
Thank you, Paul. Welcome, everybody. I see some familiar faces out there. Like Professor Kimble, I have the unmitigated gall to think that writing is a form of communication. And if it doesn't communicate, then it's not good writing, period. And putting the adjective legal in front of the word writing doesn't change that. If it's poor communication, if it's poor writing, it's not magically good writing because we inserted the word legal in front of it. And I would add, because I've got no opinions on this, I reject the dichotomy that's presented as consumer and legal. Consumer documents and then true legal documents. I reject that. I think it's a false dichotomy. Every single document is a consumer document. A statute is a consumer document. It governs our lives and we have to follow them. A contract is a consumer document, even if it's a commercial contract. An ordinance, you name it. A brief to the U.S. Supreme Court is a consumer document. Some poor soul on the other end has to make heads or tails of it. So I say every document is a consumer document, although I will be covering those that are more traditionally legal. So since sharing is caring, here we go. But you may dispute that in a second. Uh-oh. So, why don't you all give this a read? I'm going to go have a beer. And I'll be back in about a half an hour. You guys, good luck with this. Or this. I had to sign this document myself for my daughter's college apartment. People, that's not good writing just because it's legal writing. Here's a picture just in case you want to get the full impact of the wall of legalese. Can you climb that, reader? Can you climb that? I dare you. And what happens is, of course, what do you do when you see that? You just sign it. You just sign it. As Joe has shown us, we tend to think of plain language as, well, you should try the word under instead of the phrase pursuant to. That's all important. It matters. Those little decisions have a cumulative impact that's very positive. But so much of so-called plain language is organization. It's large-scale macro organization. When a legal writer presents this to a reader, it's essentially saying, reader, I'm shutting you out. I'm putting up a wall. And that isn't communication. Writing is communication. It should communicate. And here's another gem. People, I'd be embarrassed to tell you how little time I took finding these examples, which is kind of the point. It's kind of the point. This is my favorite. You'll excuse me. Herein after referred to as distribution licensee, which expression shall, unless repugnant to the context or meaning thereof, include its successors and permitted assigns. As party of the first part. And then we go down here and I see the party, the first party. Is the first party the party of the first part? I thought we were going to call them the distribution licensee. Well, wait, why are we referring to the same party in two different ways in the same sentence? This paragraph is a single sentence, in case you doubted that. So again, I don't think that this is good communication. And the reason I know that that's true is because Kanye West says it's true. And check this little gem out. Kanye West, who is a client lamenting that he can't even understand his own contract. And he went through with Twitter, with various Twitter posts, trying to set up rules that should be followed in the industry. And you can see here, the first thing that changes about record deals is lawyers. We need plain English contracts. A lawyer's role. I am quoting Kanye West. I did not expect that would happen in my career. A lawyer's role is to improve deals, not charge for contracts we cannot understand or track. That word track is very telling, because it's reflecting that readers have to navigate these documents. They've got to navigate, rewrite deals to be understandable from the first read, not 27 and a half reads, the first read. I'll tell you, speaking of elections, I just may have to write Kanye in after all. I'll tell you, after I saw this tweet, I might need to go with Kanye. I don't know about you. We could start a little movement here, surprise some people. So what Kanye is saying is, give us a chance. Maybe instead of this, maybe a little of this. This is the same thing, by the way. This is an exercise I did in class with students. I just grabbed this off the internet and gave it to the students, and I did a live redraft, and would come up with something like this, which you still have to put your thinking cap on, but we have a chance to track it using Conway's well-chosen word. We can navigate it. We have a fair chance. Contracts should not be written in a way that prevents the people who are bound by that contract from understanding what they're bound to. That's not communication. We can't disenfranchise people from their own lives. But clients want and expect legalese. Really? My buddy Chris Trudeau, one of our alums and a leader in the health literacy movement, did a little survey, and clients don't like it. Clients don't like it. Let me quickly just say again, clients don't like it. Clients are empowered by documents that allow them to understand their rights and obligations. We want to empower clients. We want to tell their story. If you're a litigator, we need to connect with a human mind and shape its perceptions. We are our client's voice. If we are not reaching and connecting with the reader's brain, we are not telling our client's story. We have to tell the client's story as attorneys. We're their voice. Oh, but judges love the legalese. Oh, the judges, they just love it. They go home at night because they haven't had enough, and they get in the recliner next to the fire with a nice bourbon, and they break out some more briefs because they like the legalese. No, I guess that's not true. Surveys show that judges prefer plain language as well. I love this from the Detroit bankruptcy case. It was a Detroit Free Press article about how the bankruptcy judge told this very, very fancy silk stocking law firm, could you please redraft this document in plain language? And I love this line right here. I wish you had an 8th grade teacher on staff to edit this for you. Now, an 8th grade teacher, mind you, really knows his stuff or her stuff. It's not easy. Plain language is not easy to achieve. That's one of the great myths. It actually takes a lot of skill and knowledge about writing. But it's something that lawyers need to educate themselves about. Here's a little U.S. Supreme Court support for my point. Terrible, terrible. That's pretty plain. This is one of my favorites, and this is not new, people. This is old news. This survey was from the late 80s. It was a survey of California appellate judges. Again, we're talking about now litigation, brief writing, and And the survey revealed that to those California appellate judges, people who write in legalese are not as persuasive, and their arguments look substantively weak. They're viewed as less credible. And there's something I didn't add here. I revisited this recently. There's actually a line in there. These judges, when there's a lot of legalese in the brief, they assume that it's not an attorney from a top firm. And that, we've got lawyers in the house here, we've got law students here, whoever we are, if we are trying to connect with a reader in the courthouse, we need to think those are busy people who do not love legalese. And you just might even get into a little hot water with the US Supreme Court if you don't follow the Supreme Court rule that says that petitions for cert should be in plain terms. There's all kinds of court rules, etc. So anyway, that's how I feel about the importance of plain language. And I will look forward to questions and discussion.
Sure. Carmen in the chat brings up an interesting point that so many of us now are on our phones and just pressing I agree to a bunch of different agreements that we're never reading. Do you think that from either one of you that has we seen situations where people have been pressing agree, whether it be online or otherwise, without having really read or just don't understand what they're reading, and have gotten themselves into difficult situations as a result of it, whether it be a land issue or a medical issue, or I accept my agreement that I now made with Amazon. Do you find that there's a case law growing in these areas at all? Do you know that? You're muted, Joe.
I have not seen any cases. I don't know, Mark, whether you have, but of course we all just click I agree, and it just does not have to be this way. And almost all companies just do this. Their lawyers do it. They don't have it reviewed by anybody that's an expert in plain language. I mean, these companies ought to have, all big companies ought to have plain language experts on staff. Big law firms ought to have plain language editors on staff. Yes, I mean, we all, we're used to signing all these things, and we don't complain, but we should, because we don't complain because we're in such a big hurry. But right. It's unconscionable for these companies to keep writing these impossible terms and conditions that nobody can understand, nobody has the time to read. I mean, get a conscience and find some people that can do this in plain language.
Yeah. Both of you mentioned legalese, use that terminology. Do you think that the use of legalese has created distrust of lawyers in the legal profession? Is that a contributor to people that may not trust the legal process?
Maybe I'll jump in here, Joe. And I think this kind of connects back to the last question. Why does nobody read that language? We just click yes. Why did I just sign the form for my daughter's apartment? We've been conditioned. People have been conditioned year after year, decade after decade, to know that it's just going to be a bunch of gobbledygook, often in fine print. They know that if they stop and try, it's not worth the effort because it's impenetrable, it's inaccessible. And there are, I should say, on the bright side, I have seen some kind of refreshing exceptions to that rule. I've seen there are some companies that are now making a real effort to use plain language techniques, question style headings, and what have you, in ways that I think not only make it clear, but also build trust. Rather than putting the wall between consumer and company, it can be a marketing tool. It can be a marketing tool. I've seen law firms on their homepage talk about legal ease, EASE, as a marketing tool for clients. So I think there is some movement. There is some movement.
I'm wondering, has anybody created a list of plain language friendly corporations that you know of? There's a next step for you, Joe.
Yeah, I got enough to do. Not that I know of. I mean, one of the problems is that these initiatives come and go in different companies or organizations or government agencies. You'll get somebody in there that tries to promote it, and the effort will go on for a few years, and then they'll have budget cuts. Even though some of the numbers in my book, among the many numbers in my book, the state of Washington figured out that for every cent that they spent, for every 1 cent that they spent in developing this income tax form, it returned $1. It returned $1 on average. And so, yes, companies, it will take some upfront costs, but it will pay off big time if you do it right.
Right.
In the long run.
Yeah. Follow up. Aisha's asking, how do we make the initiatives that you talk about stick? As you say that there are budget cuts and other reasons why companies, find the momentum to create a plain language movement within their corporate structure, but then it kind of falls to the wayside. How do we indoctrinate the practice of using plain language and make it stick?
Well, yeah. If I knew the answer to that, I could change the world. But yeah, I mean, what happens is that people of influence leave. You'll have a CEO or maybe a department director who sets up a program, does the training, does the follow-up, then he leaves or she leaves.
Right. Carmen,
so a lot of different reasons why they don't tend to last. Now we do have in the federal government we have the Plain Writing Act since 2010. So there's some very encouraging things going on in the U.S. Federal government in some agencies. I think I saw Catherine Spivey on here earlier, if she's still on. But yes, and we have a Center for Plain Language in D.C. and some of the government agencies are doing a pretty good job. And there is and every year the Center for Plain Language issues a government report card and actually gives grades to the different agencies. And you've got always some winners and you've got some losers that don't perform well. But you've got to have leadership. You've got to have leadership from the top.
And maybe a little bit of maybe a little peer pressure as well. For the Center for Plain Language, I judge the Clearmark Awards each year, and you see there's some pretty big insurance companies that every single year they've got multiple entries. They're putting a lot of money into their communication with policyholders. They're proud of what their people are producing, and they keep entering. And I'd like to think that when one of those companies gets the nod, gets this positive attention, that maybe other companies that are similarly situated might take notice and say, that might be something worth doing. That's some good press. It's good publicity, and it's all about taking care of our policyholders, customer relations.
Right.
Yeah. And I might mention the social media for the consumer is also an avenue if you have enough. I mean, those of you that follow me on Twitter will know that I am often jumping in and complaining about customer service from this company or that company. And you will get a response very quickly from the support staff. Of course, what they will say is, please send us a direct message.
Yeah.
Please send it. In other words, they don't want you to go they don't want you to do anything more publicly. Yeah.
The timing is perfect. Professor Randall, Tori Randall's here. Could you unmute and just talk about it? You asked, is there an anthology or I'm sorry, analogy to tweets for young writers, because you introduced the idea of social media. What are you thinking there? What's the analogy?
I was following up on the previous point about the sticking power, and I think to the point about if we introduce this to students when they're young, might it stick? And it just got me thinking that as we have more people having to make their point in a very small number of words, maybe that's relatable in talking to young people about the importance of plain language. And it made me think too of this disruptor economy where, you know, a lot of companies are trying to be sharp and quick and do things differently, and maybe that will all help propel it forward.
Yeah. LOL. We're moving along here, but I'm really, Joe, I've never asked you this question, but what got you involved in the plain language movement to begin with? How did this happen for you?
Well, I actually tell that little story in one of my books, but basically the timing was just right. I mean, this goes to show you how hard it is to get through to lawyers on this. And by the way, I don't think it's a conspiracy. People say lawyers do it deliberately to make money. I don't think so. I think it's inertia and habit and poor models and so on. But at any rate, so I was an English lit major and went to law school, and it never occurred to me that anything was wrong. You know, I mean, how could I have been so blind? But then after I graduated, for a short time, I was working at the Michigan Supreme Court and was working on court rules. And there was only one writing book out there at the time, really. It was by Reed Dickerson called The Fundamentals of Legal Drafting. And he had some pages where he would say, don't use this, left-hand side of the page, right-hand side, use this. And I thought, he's right. I mean, he's right. He's right. Why do we do this? You have to have the sort of that moment that comes down and strikes you and says, wait a minute, why are we doing this? And that just happened to coincide with the plain English. It was called plain English at the time. Now we call it plain language. And about the same time, you know, with the plain English movement as it was getting off the ground in the United States in the middle and late 70s. And so I was an early convert.
And so then you come to WMU Cooley and you incorporate that into the writing program. Is that a true assessment?
That is a true assessment.
Okay, because Aisha was saying earlier that maybe the one way to make it stick is to start right in law school, which WMU Cooley's been doing forever since its inception. Mark, now, do I have this right? Were you a student of Joe's?
I've been a student of Joe's for a long, long time now, but I was a student of Ann Wing. She's wonderful, was wonderful. I enjoyed her class so much and learned so much from her. So I didn't have to run the Joe gauntlet.
But how did you become a believer? When did you become a believer?
Well, I like to do what I'm told. So Anne told me to use plain language, so I did what I was told. And then I went out into practice, and I still remember the very first week out in practice, I had one partner at my firm tell me that he liked to dictate his documents into the dictaphone. That used to be pretty common. I don't know if it's still common. But he said, I like to dictate my briefs because, and this guy was just a fantastic appellate specialist, great lawyer. His writing was top notch. And he said, I like to dictate my briefs because I tend to use more plain language when I'm speaking rather than if I'm typing. And then in a moment of weakness, now you're making me say this in front of Joe Kimble, Paul, this is not fair. But in a moment of insecurity, in my first week in practice, I think I wrote something like in the case at bar or something like that. And another partner just killed it with red ink right there. And I said, I got to do what Ann told me. Professor Ann Wing told me to do. And then very quickly, interacting with judges and handling cases, the power of plain language brief writing, the power of it, unmistakable. And And I've been spoiled rotten with amazing mentors in my career. Just spoiled rotten. And every step of the way, from my law school professors to the different law firms, and we all had this plain language ethos in our brief writing, and for a lot of my career, for the majority of my career, I was representing lawyers and law firms that had been sued for legal malpractice. My clients were lawyers, and they would review my brief before it was filed, and they loved the style of our briefs. I think they just felt like somebody was actually telling their story.
Right.
Finally, just shedding the stuff.
Right.
Shedding the stuff that so many lawyers just get bogged down in because they think you're supposed to do it that way. Just shedding it, and again, just trying to get right to help busy people understand easily. And we, very sophisticated business clients, they all just loved it. So when I hear lawyers say, "Oh, clients like the legalese stuff, they're getting their money's worth," I don't buy it.
Mm. There have been a number of comments in the chat about international. This is being an international movement, the plain language movement. Is the U.S. leading in this movement, Joe? You mentioned this too a little bit about. You gave examples in your book from other countries. Who's doing this well internationally?
The Scandinavian countries are doing it very well. And they've always been leaders in plain language. The Australians were some of the early leaders in plain legal language. But the Scandinavian countries are doing it well. I think there should be a link in the chat to some studies out of Norway that came along after I wrote my book, or I would have had them in the book, again, with these same kinds of incredible numbers before and after language. Is that link in there, Terry? To the Norway publication?
Yes, I've added all the links.
Good.
The
Okay.
first ones, the very first
Right.
ones.
Yeah, the chat is chock full of information in there. If you want to take a gander, Joe, we can't leave either today without talking about the Kimble Writing Center, which is launching and has been around for a few years here now. So tell folks that aren't necessarily familiar with the Kimble Writing Center what you're trying to do there.
Well, the Kimble Center for Legal Drafting, which Cooley Cooley approved in 2018. And the first thing I want to say is it was not my idea. I did not hatch this Kimble Center for Legal Drafting, let alone named after me.
If I could jump in,
I think the research and writing department, led by Mr. Cooney, had this idea, and but anyway, it's an honor. And what we're trying to do is a couple of things. We're trying to give seminars for lawyers, law students, paralegals. We gave one of those just about a year ago. We're going to do another one in the spring. It'll be virtual, no doubt. We're trying to prepare some common legal documents and make them in plain language, of course, and make them available to the public. We've done a medical power of attorney. It's available for free on the website. I think there's a link to that, right, Terry, in the chat. And we're trying to figure out what other kinds of projects we might be able to. I'd love to, but you see, it takes resources. It takes resources. And I mean, I'd like to do kind of an inventory of. And I got this idea from from the virtual seminar that I attended last week about. It'd be great to do kind of an inventory of the charging documents in criminal cases, or the sentencing documents in criminal cases, which of course people don't understand. And see whether we might be able to become involved in some projects like that. So it basically has a public service mission.
Excellent. And if folks want more information about that, they can be found on the WMU Cooley website, wmich.edu/law. And we'd be happy to have you take a look at that. Also today, I would be remiss if I didn't mention President Dean Emeritus Don LeDuc is here, who's a major supporter of the Kimble Center, which we appreciate. Thank you very much.
I didn't know that Don was on. Let me just.
Yeah, I just saw him peek up. He's moved up in the pecking order here. So
Yes, absolutely. I mean, Don was the one who, former President LeDuc was the one who signed off on the Kimble Center.
Yes, excellent. Mark, so in our curriculum, in the WMU Cooley curriculum, research and writing is in the second semester, sometimes depending upon the schedule option, I may move into the third. First day of research and writing class, how are you talking about to the class about plain language, or are you?
Well, that's a good question. I'll tell you how I do it. We really do our best to help students get a feel for every type of document they could possibly be asked to write in a law office. And so I start right off with an email to the boss. And it's a great little kind of, it's a little vehicle overview for the entire course. And I usually walk into the classroom or now put my face in front of the computer and I pretend that we're going to have to cancel class because I just got a call from my buddy at my old law firm who's got a question and we need to come up with an answer and send him an email. And then we do a little quick research together. And then I say, now we're going to send this email. If you were the reader, if you were on the receiving end of this email, what's the first thing that you would like to know? Okay, what's the next thing you'd like to know? And should we just leave it a big solid wall of unbroken text? Oh, a new paragraph to give the reader's eye rest? And we start to walk through and every word out of my mouth is, if you were the reader, what would you need? What would you want? What would allow you to access the information in a way that made it easy for you to process and make use of? And so from that very first class session, I want them thinking from then on for the rest of their lives, it's all about the reader. Nothing matters but the reader. We have to reach our reader. And by definition, readers in this business are busy as heck, and they've got a pile like this to get through. And I tell them, we start with the subject line. This person receiving this has 37 emails to open. What's an informative subject line? So anyway, it's all about the reader. That's my message from the first minute of class until my dying breath.
I mean, that is so true. Yeah, it's completely reader centered, and yeah, and it should be clear by now, especially from Mark's examples, that it's about much more than sentences and words. It's about all the techniques for clear communication, including importantly design. Something that I, frankly, didn't come to or didn't appreciate early on.
Yeah, and the ballots are a great example that you gave in the very beginning, Joe. That's very clear that design does play a major role in this as well. Speaking of class, Professor Cooney, I know that you have one at 6, so I'll turn to the group and see if we have any final questions for our distinguished guests today. And if there are not, we can come together again at our next WMU Cooley conversation. Any further comments or commentary from our speakers or from any of our guests today? Well, we thank you for joining another WMU Cooley conversation. And again, we thank Professors Cooney and Kimble. We thank all of you for participating, particularly those who may be future lawyers coming down the pike here. We were going to be sending you a survey after this. If you could take a moment and complete it. Until our next time together in a WMU Cooley conversation, please stay safe and let's care for one another. Have a great night.
Hi, everybody. Thanks for coming.